Before we begin, a quick and important disclaimer. This video is intended strictly for educational and entertainment purposes. It does not constitute legal, religious, or psychological advice. The intersection of Islamic jurisprudence and United States civil law is a complex field that varies significantly by state and individual circumstances. You should not rely on this information as a substitute for consultation with qualified legal professionals or recognized religious authorities. Every case is unique, and viewers are strongly encouraged to conduct their own due diligence and seek expert counsel regarding their specific situations. The American Muslim community is currently navigating a quiet, domestic revolution that is reshaping the very fabric of its social structure. For decades, the topic of divorce was whispered about in the corners of community centers or hidden behind the closed doors of suburban households. But today the data tells a different story. Recent historical trends suggest that divorce rates within Muslim American households are rapidly converging with the national U.S. average, which hovers near 50%. This is not just a statistic, it is a seismic cultural shift. We are witnessing the collapse of the traditional immigrant marital contract and the rise of a new, complex identity where ancient religious principles must negotiate with modern American civil rights. For many, this has created a state of legal and spiritual limbo, where a woman might be civilly divorced in the eyes of the state of New York or Texas, yet remain religiously bound to a man she no longer lives with in the eyes of her community. This is the phenomenon of the limbo divorce, and it is just the tip of the iceberg in a deep dive into how faith, law, and culture collide in the modern West. This video is designed to serve as a comprehensive masterclass for anyone trying to understand the evolution of family dynamics in a minority context. We are going to deconstruct the three-tiered system of divorce that American Muslims must navigate: the religious, the civil, and the social. By the end of this deep dive, you will understand how the interpretation of the mahr or dowry is being challenged in U.S. courtrooms, why the role of the local imam is changing from a judge to a counselor, and how the economic independence of Muslim women in the U.S. is fundamentally altering the power balance of the traditional household. We will explore the potential outcomes of these shifts and look at case studies that illustrate the high stakes of modern marital dissolution. This is about more than just the end of a marriage. It is about the evolution of an entire culture as it settles into the American landscape. To understand where we are, we must first look at the historical trends of the last 40 years. When the first major waves of professional Muslim immigrants arrived in the U.S. following the Immigration and Nationality Act of 1965, the focus was on survival and assimilation. Marriage was often seen as the ultimate anchor. In those early decades, divorce was rare, not necessarily because marriages were perfect, but because the social cost of leaving was too high. The community was small, and the shame of a failed marriage could result in total social ostracization. However, as the second and third generations have come of age, the cultural calculus has changed. These generations are increasingly educated, financially independent, and deeply integrated into American norms of individualism and self-fulfillment. They are less likely to stay in a marriage that is emotionally unfulfilling or abusive simply to maintain appearances. The primary friction point in this evolution is the duality of the marriage contract. In Islam, the nikah is a legal contract, not a sacrament in the way it is viewed in some Christian traditions. In the U.S., this religious contract often exists alongside a civil marriage license. This creates a fascinating and often volatile legal overlap. For instance, consider the mahr. This is a mandatory gift given by the groom to the bride at the time of marriage, which remains her exclusive property. In many traditional contexts, part of this is paid up front, and a larger portion is deferred, payable upon death or divorce. In an American context, when a couple files for a civil divorce, the question arises: is the mahr a prenuptial agreement? U.S. courts have struggled with this. Some states, like New Jersey, have historically looked at the mahr as a simple contract and enforced it, provided it met the basic requirements of contract law. Other states have been more hesitant, viewing it as a religious matter that the state should not interfere with, or conversely, as a document that does not meet the rigorous full disclosure requirements of a standard American prenuptial agreement. This leads to cases where a woman may be entitled to half of the marital assets under civil law, but her husband may argue that her only entitlement is the mahr specified in the nikah. These case studies reveal a profound tension between the protective intent of Islamic law and the equitable distribution principles of U.S. civil law. Furthermore, we must examine the silent divorce, or the religious lockout. In traditional Islamic jurisprudence, the power to initiate a talaq, or unilateral divorce, historically rested with the husband. While women have the right to khula, which is a divorce initiated by the wife, it often requires the husband's consent or the intervention of a religious judge. In the U.S., where there is no formal Sharia court system with legal enforcement power, some men have used this religious requirement as a weapon. They may grant a civil divorce to comply with U.S. law, but refuse to grant the religious divorce. This leaves the woman chained, unable to remarry within her faith community because she is still religiously married to her former husband. This has led to the emergence of domestic violence advocates and religious leaders who are pushing for the inclusion of Islamic divorce clauses in civil marriage contracts to prevent this kind of spiritual abuse. The psychological and social evolution is equally significant. In the past, the local imam was often the sole arbiter of marital disputes. Today we see a shift toward professionalization. Many American mosques now require couples to undergo marital counseling with licensed therapists before an imam will perform the nikah. This represents a recognition that religious guidance must be paired with clinical understanding of communication, trauma, and mental health. The stigma of divorce is also being actively dismantled by a new wave of Muslim influencers, scholars, and activists who argue that the Prophet's own community was one where divorced individuals were integrated and supported, rather than shamed. This deep dive into the cultural evolution of divorce in the U.S. is not just about the breakdown of families. It is about the maturation of a community. It is about the transition from a diaspora mindset to an indigenous one. As American Muslims increasingly turn to civil courts for protection and to religious leaders for spiritual closure, the two systems are beginning to influence one another. We are seeing the development of a unique American Muslim common law, a set of practices and expectations that blend the ethical framework of Islam with the egalitarian values of the American legal system. In the segments to follow, we will look at specific data points regarding the economic impact of divorce on Muslim women, the rising trends of gray divorce in the community, and the step-by-step process of how modern couples are restructuring their lives after the end of a marriage. This is a story of resilience, legal complexity, and the ongoing search for justice in a changing world. To understand how this legal and cultural friction functions in real time, imagine the case of Sarah, a 34-year-old software architect living in the suburbs of Chicago in the year 2026. Sarah has been married to Omar for 12 years. They have 2 children, a mortgage on a home in Naperville, and significant retirement accounts. When they married in 2014, they signed a nikah contract that specified a deferred mahr of $50,000. In 2026, as Sarah files for a civil divorce in Cook County, she faces a multi-layered legal puzzle that many of her non-Muslim neighbors would find incomprehensible. In the eyes of the state of Illinois, the court is primarily concerned with the equitable distribution of marital assets and the best interests of the children. However, Sarah is also navigating a religious framework where the mahr is considered a debt owed to her by Omar, independent of any civil asset division. This leads us to a critical examination of how U.S. civil courts handle the Islamic marriage contract in 2026. Historical trends over the last decade show a significant split in judicial philosophy. We have seen case studies in states like New Jersey and California where judges have increasingly viewed the nikah as a valid, enforceable contract under the neutral principles of law approach. Under this doctrine, a court can enforce a religious contract as long as it can do so without interpreting religious doctrine or entangle the state in theological disputes. For Sarah, this means her attorney must argue that the $50,000 mahr is not a religious tithe, but a secular contractual obligation, similar to a promissory note. If the document is clearly written and signed by both parties with proper witnesses, the court may award her that amount on top of her share of the marital estate. However, the potential outcomes shift dramatically if the contract is poorly drafted. In many historical trends, we see cases where the mahr was written on a napkin or a generic mosque template without specifying whether the amount was in US dollars or another currency, or whether it was intended to be a prenuptial agreement that waives other marital rights. In 2026, many husbands are now counter-arguing that the mahr was intended to be the total sum of the wife's entitlement, attempting to use Islamic law to circumvent U.S. community property laws. This creates a high-stakes legal battle where Sarah's legal team must demonstrate that she did not knowingly and voluntarily waive her rights to Omar's pension or the equity in their home, simply by signing a religious document a decade ago. Beyond the courtroom, we must look at the step-by-step evolution of religious authority. In 2026, the role of the local imam has undergone a professional transformation. Gone are the days when a community leader would simply tell a woman to be patient and return to a difficult home environment. Modern American imams are increasingly educated in social work and domestic violence advocacy. They are now working in tandem with professional mediators. Imagine Sarah visiting her local Islamic center seeking a religious divorce, or khula. In 2026, she is likely to be met not just by a scholar, but by a reconciliation committee that includes a licensed therapist and a female counselor. This committee follows a structured protocol. First, an assessment of the physical safety of all parties. Second, a review of the civil filing status to ensure legal consistency. And third, a mediation process that focuses on the ethical fulfillment of financial obligations. This brings us to the concept of the religious lockout, a historical trend that has reached a boiling point in 2026. For years, women like Sarah could be civilly divorced but religiously chained if the husband refused to grant a talaq. In the current year, we are seeing the emergence of standardized prenuptial addendums endorsed by major American Muslim organizations. These documents stipulate that if a civil divorce is finalized, the husband agrees to grant a religious divorce immediately. Case studies from 2024 and 2025 show that these addendums are being used to provide women with the spiritual freedom to move on. If a man refuses in 2026, he faces not just social pressure, but potential civil litigation for breach of contract, as these addendums are being drafted to be legally binding in U.S. courts. Data from the American Muslim Bar Association indicates a 40% increase in the use of these specialized prenuptial agreements over the last 5 years. This shift reflects a move toward legal self-protection and a recognition that religious and civil lives cannot be entirely separated. We must also consider the economic evolution of the Muslim American woman. In 2026, Muslim women in the U.S. graduate from higher education institutions at rates that often exceed their male counterparts. This economic independence is a primary driver of the cultural evolution of divorce. When Sarah has her own high six-figure salary and a robust professional network, the traditional leverage of financial support, used by some to keep women in marriages, is neutralized. She is no longer staying for a roof over her head. She is staying only if the partnership is healthy and equitable. This economic shift has also changed the social stigma. In the immigrant communities of the 1980s, a divorced woman was often viewed as damaged goods. In 2026, the narrative has shifted toward empowerment and health. We see this in the rise of support groups specifically for divorced Muslim parents, where the focus is on co-parenting and psychological well-being. The culture is moving from a shame-based model to a growth-based model. However, this transition is not without friction. Older generations often view this as a surrender to Western individualism, leading to significant intergenerational conflict within households. The grandmother in Sarah's family might see the divorce as a failure of the family's honor, while Sarah sees it as a necessary step for her mental health and the stability of her children's future. To analyze the complexity further, let us look at the step-by-step process of asset liquidation in a 2026 Muslim divorce. It is not just about the house and the car. There are often complex international assets involved. Many families hold property in their home countries, such as Pakistan, Egypt, or Jordan. In Sarah's case, Omar may have inherited land in the outskirts of Lahore. A U.S. court has no jurisdiction to transfer a deed in Pakistan, but it can take the value of that land into account when dividing the assets located in the U.S. This requires forensic accountants who specialize in international Sharia-compliant finance. The intersection of these two worlds requires a level of expertise that was rare 20 years ago, but is now a standard requirement in 2026 for high-net-worth divorces in the community. The ripple effects of these divorces extend to the children, who are growing up in a world where their identity is split between two distinct legal and moral systems. They watch their parents navigate a process that requires both a judge's decree and a scholar's blessing. This duality is forging a new American Muslim identity, one that is more comfortable with complexity and less reliant on the rigid social structures of the past. But as we see this evolution toward legal and social clarity, a new and darker trend is emerging that threatens to undermine this progress. There is a growing movement of men who feel marginalized by these new protections and are turning to digital spaces to coordinate a new kind of resistance. What happens when the digital world becomes the new battleground for marital disputes? In the next part, we will explore the rise of digital harassment and social media shaming as a tool of marital warfare in 2026. We will look at how the concept of honor is being weaponized in the age of viral videos, and the devastating impact this has on the privacy and safety of families. We will also dive into the controversial rise of online Sharia councils that operate outside the bounds of local mosques, councils that any person can access from their smartphone, often with disastrous results for the traditional authority of the community. What does it mean for the future of the family when a stranger on another continent can issue a fatwa that ends a marriage in California? The answer lies in the blurring lines of the digital and the spiritual. The digital shift has transformed the private agony of marital breakdown into a public spectacle, creating a new and dangerous frontier for Muslim families in the United States. In the year 2026, the traditional concept of honor or haya is being radically redefined by the presence of a permanent digital footprint. Imagine a young woman named Aisha, a marketing professional in Irvine, California. As she navigates the early stages of a civil separation from her husband, Yusuf, she discovers that the battle is no longer confined to the sterile environment of a courtroom or the quiet office of an imam. Instead, her personal life has become content. Yusuf, feeling a loss of control in the civil process, begins utilizing social media platforms to narrate his version of the marriage. He doesn't just share his feelings, he utilizes a strategy of algorithmic shaming. By posting carefully curated snippets of private arguments, out-of-context screenshots of text messages, and even recordings from home security cameras, he creates a narrative designed to trigger the community's collective sense of moral outrage. This phenomenon of digital honor weaponization is a documented historical trend that has accelerated sharply between 2022 and 2026. In the past, gossip was limited by geography and the speed of human speech. Today, a viral video can reach thousands of community members across the country in minutes, effectively excommunicating an individual before they have even had their first hearing in a family court. For Aisha, the potential outcomes are devastating. She finds herself blocked from community WhatsApp groups, her professional reputation is questioned by local clients who see the viral posts, and her parents face intense pressure from their social circles to force her back into the marriage. This is the new reality of marital warfare in 2026. The leverage is no longer just financial or legal. It is the threat of permanent digital infamy. Step by step, we must analyze how these digital artifacts enter the U.S. civil legal system. In 2026, forensic digital discovery has become the most time-consuming and expensive part of a divorce. Attorneys now employ specialized investigators to scrape social media, recover deleted messages, and track the metadata of files used in online shaming campaigns. When Yusuf posts a video of Aisha without her hijab to shame her religiously, his legal counsel might argue it was a form of self-expression or religious frustration. However, Aisha's legal team can use that same video as evidence of coercive control and harassment. U.S. courts in states like California and New York are increasingly recognizing digital shaming as a form of domestic abuse, often referred to as domestic violence by proxy. This can significantly influence custody battles, as a parent who demonstrates a willingness to humiliate the other parent publicly is often viewed as being unable to facilitate a healthy co-parenting environment. Beyond the social media platforms, we are witnessing the rise of the e-Mufti and the decentralized online Sharia Council. In 2026, the authority of the local neighborhood imam is being challenged by global digital platforms. These sites allow individuals to submit their marital grievances anonymously to scholars located in London, Riyadh, or Cairo. For a small fee, these platforms issue a fatwa, or a non-binding legal opinion, on the validity of a divorce or the custody of children. The danger here is the lack of context. A scholar sitting in a different legal and cultural environment may issue a ruling that completely ignores the reality of life in the United States. Yusuf might present a one-sided story to an online council in Malaysia and receive a document claiming he has the sole religious right to custody. He then presents this to Aisha as a divine mandate, despite it having zero legal standing in the California court system. Case studies from 2025 highlight several instances where these online fatwas were used to justify parental kidnapping or the withholding of financial support. Because these online councils operate in a digital gray zone, they often bypass the rigorous mediation and verification protocols that a local American mosque would require. The local imam knows the family, understands the history of the relationship, and can see the nuances of the situation. The online scholar only sees the text on the screen. This creates a fragmentation of authority that leaves many families in a state of spiritual confusion. The woman may feel religiously obligated to follow the online ruling, even if it contradicts her civil rights and the best interests of her children. The psychological impact of this digital duality is profound. In 2026, we are seeing a rise in what psychologists call spiritual trauma caused by digital religious arbitration. When a stranger halfway across the globe tells you that your civil divorce is a sin, or that you are no longer part of the faith because of a decision made in a U.S. courtroom, it creates a deep sense of alienation. This is compounded by the speed of the internet. A religious ruling that used to take months of consultation can now be delivered to a smartphone in seconds, often without the necessary emotional support or pastoral care that should accompany such significant life changes. Furthermore, we must look at the historical trends regarding the privacy of the next generation. The children of these 2026 divorces are the first to grow up with their parents' marital conflicts archived forever on the internet. In our scenario, Aisha and Yusuf's children will eventually reach an age where they can search for their parents' names and find the very videos and posts used during the divorce. This creates a secondary layer of trauma that is only now being studied. Professional mediators in the Muslim community are now advocating for digital peace treaties as part of the divorce settlement. These are legally binding agreements in civil court where both parties agree to delete all social media content related to the marriage and refrain from making any future posts that mention the other party or the children. Potential outcomes for those who refuse to adapt to these digital realities are increasingly severe. We are seeing cases where individuals are being sued for defamation in civil court for their religious shaming tactics. In 2026, a post on a community Facebook group is no longer seen as a private religious matter. It is seen as a public statement subject to libel laws. This intersection of civil defamation law and religious discourse is a primary area of growth in American Muslim legal practice. It forces a professionalization of how people speak about their private lives, even within their religious communities. As we examine this landscape, it becomes clear that the digital world has not just reflected the evolution of divorce in the American Muslim community, it has accelerated it. It has created a high-speed feedback loop where cultural norms are challenged and rewritten in real time. But even as the digital battlegrounds expand, there is an even more complex layer beneath the surface. It is the layer of money, specifically the intersection of Sharia-compliant finance and the Western banking system. In a world of cryptocurrency, international wire transfers, and complex business structures, how do you fairly divide assets when the two systems have fundamentally different definitions of ownership? In the next part, we will peel back the curtain on the high-stakes world of Islamic financial settlements in the U.S. We will look at how high-net-worth individuals are utilizing trust structures to shield assets, how the concept of interest-free loans within families creates massive legal headaches during a divorce, and the specific step-by-step challenges of liquidating Sharia-compliant investments. How do you split a joint account that was never supposed to exist in the first place? The financial fallout is where the abstract theories of the digital world meet the hard reality of the bank balance. The financial fallout of a Muslim divorce in the United States during the year 2026 is often described by forensic accountants as a Rubik's Cube where the colors keep shifting. To understand this, let us look at the case study of Zaid, a 42-year-old artificial intelligence consultant living in Austin, Texas. In April 2026, Zaid and his wife Huda decided to end their 14-year marriage. On the surface, this looks like a standard high-net-worth divorce in a community property state. However, beneath the surface lies a complex web of Sharia-compliant financial structures that the Texas legal system is only beginning to learn how to untangle. The first major point of friction is the definition of ownership. In the Islamic legal tradition, there is a strict separation of assets. What Huda earned during the marriage is hers, and what Zaid earned is his, provided they did not explicitly pool their resources. However, in Texas, almost everything acquired during the marriage is considered community property, subject to a 50-50 split. In 2026, we are seeing historical trends where Muslim women, who have been encouraged by cultural norms to keep their inheritance and earnings separate, are now finding themselves in a dual advantage or dual disadvantage position. If Huda has a separate inheritance of $500,000 sitting in a Sharia-compliant brokerage account, under Islamic law, Zaid has zero claim to it. But under Texas law, if that account generated dividends or interest-equivalent returns during the marriage, those returns might be considered community property. This leads us to the step-by-step complication of the Sharia-compliant mortgage. Zaid and Huda bought their home using a diminishing musharaka model, a common historical trend in 2026 for American Muslim families who avoid traditional interest-based lending. In this model, the home is not owned by the couple with a lien held by a bank. Instead, The home is owned by a limited liability company or a co-ownership entity where the couple and the Islamic finance company are partners. Each month, Zaid and Huda paid a sum that consisted of two parts: a buyout of the company's shares and a rental fee for the portion of the home they did not yet own. In a 2026 divorce court, a judge faces a logistical nightmare with this structure. Since the couple does not technically hold a traditional title with a standard mortgage, the court cannot simply order a refinance in one person's name. The Islamic finance company is a third-party partner that must consent to any transfer of shares. The potential outcomes here are often expensive. If Zaid wants to keep the house, he must essentially buy out both Huda's shares and the finance company's shares, often requiring a massive liquidity event that may not be possible without selling other assets. Case studies from 2025 show that many families are forced to sell these homes at a loss because the co-ownership contracts are not easily transferable under the pressure of a fast-moving divorce decree. Then we have the issue of the bank of dad. In many Muslim American households, large sums of money are moved between family members based on verbal agreements and religious trust. In 2023, Zaid's father, who lives in Dubai, wired $400,000 to Zaid to help him launch his consulting firm. In the cultural context, this was a card hasan or a beautiful loan, an interest-free loan that Zaid was expected to pay back whenever he was able. There was no promissory note, no repayment schedule, and no filing with the IRS. Now, in 2026, Huda's legal team is arguing that this $400,000 was a gift to the marriage, meaning the business equity it created is a community asset. Zaid's father is now being pulled into a U.S. deposition, trying to prove through 5-year-old WhatsApp messages that the money was a debt, not a gift. This is a recurring historical trend that highlights the danger of blending informal cultural financing with the rigid documentation requirements of the U.S. legal system. Step by step, the forensic process in 2026 has evolved to track these informal flows. Forensic accountants now use specialized software to analyze years of Zelle, Venmo, and international wire transfers to reconstruct these handshake deals. They look for patterns of small repayments or coded language in digital communications to determine the true nature of the funds. For Zaid, the potential outcome of failing to prove the loan could mean Huda receives an extra $200,000 in the final settlement, effectively forcing Zaid to pay his wife for money his father intended for him alone. We must also address the 2026 reality of Sharia-compliant digital assets. Zaid has a significant portfolio of cryptocurrency and NFTs that he considers halal investments. Dividing these assets requires more than just a public key and a password. It requires an understanding of the tax implications of liquidating these assets in a year where the IRS has implemented strict new reporting requirements for digital property. If the court orders Zaid to transfer half of his Ethereum to Huda, who is responsible for the capital gains tax? In many cases, the transfer itself might trigger a taxable event that neither party anticipated. Furthermore, the MAR, which we discussed in previous segments, remains a volatile variable in the financial spreadsheet. In 2026, we are seeing more cases where the MAR is being used as a bargaining chip. Zaid might agree to pay the deferred MAR of $75,000 immediately in exchange for Huda waiving her claim to his retirement account. However, this only works if the civil court recognizes the MAR as a valid offset. Some judges in 2026 are increasingly skeptical of this, viewing the MAR as a religious obligation that should not interfere with the equitable distribution of secular assets. This means Zaid could end up paying the MAR religiously and still losing half his retirement civilly. This financial complexity creates a high-stress environment that often leads to a breakdown in communication, which is where the community's social fabric begins to tear. As the bank accounts are frozen and the forensic experts begin their work, the news of the financial battle inevitably leaks to the broader community. This is where the cultural evolution takes a sharp turn towards social consequence. In the year 2026, a man's credit score is not the only thing at risk. His social credit within the community is also on the line. But what happens when the financial battle is won, but the social war is lost? In the next part, we will explore the devastating phenomenon of community shunning and the unofficial blacklists that emerge in the wake of a messy divorce. We will look at how local businesses, social circles, and even professional networks in cities like Houston and Patterson are reacting to divorced individuals. We will dive into the rise of the divorce party versus the period of mourning, and how the younger generation is creating entirely new social ecosystems to survive the fallout. The financial ledger is only half the story. The real cost is often measured in the people you can no longer call friends. In the year 2026, the social landscape for a divorced individual in the American Muslim community has become a complex grid of digital exclusion and physical isolation. Consider the case of Fatima, a 38-year-old pediatrician living in Northern Virginia. Following her civil and religious divorce in early 2026, she experienced what sociologists are now calling the social death sentence. Within weeks of the announcement, Fatima was quietly removed from 3 different community WhatsApp groups: one for local mothers, one for professional networking, and one for her neighborhood Quran study circle. This was not a formal expulsion but a silent erasure. In the tightly knit social ecosystems of cities like Patterson, Houston, or Dearborn, being removed from these digital hubs is the equivalent of being locked out of the town square. The mechanics of this ostracization follow a predictable step-by-step progression that has become a distinct historical trend in the mid-2020s. The first step is the digital cooling. It begins with the cessation of likes and comments on social media posts. The second step is the event filter. Fatima noticed that while her married friends continued to post photos from weekend brunches and community dinners, her invitations had simply ceased. When she questioned a close friend, the response was a vague explanation about not wanting to make things awkward or a presupposition that she would want her space. This highlights a critical cultural friction. In a culture that prioritizes the family unit as the primary building block of society, the individual who exists outside that unit becomes a structural anomaly. By mid-2026, we are seeing the rise of what can be described as the unofficial community blacklist. This is particularly prevalent in professional circles. Imagine Michael, a convert to Islam and a successful civil engineer in Columbus, Ohio. After his divorce, Michael found that his professional referrals from within the community began to dry up. In 2026, many community-run business directories and professional guilds have unwritten codes of conduct. A man who is perceived to have abandoned his family, or who was involved in a high-conflict divorce, often finds himself shadow banned from community-sourced contracts. The data suggests that for Muslim men in the U.S., the professional fallout of a divorce can result in a 15 to 20% decline in local business revenue within the first year, as social trust is inextricably linked to marital stability. However, the year 2026 also marks the emergence of a countercultural movement, the professionalization of the second chance. We are witnessing the birth of entirely new social ecosystems designed specifically for the divorced and the widowed. In major urban centers, there has been a 300% increase in the formation of divorce support cooperatives. These are not just therapy groups, they are full-scale social alternatives. Fatima, for example, eventually found solace in a group called the Mid-Atlantic Rebirth Network. This organization provides a parallel social structure where divorced individuals can network, socialize, and even co-parent, without the hovering shadow of judgment from the married majority. These networks are utilizing localized apps to coordinate childcare swaps and holiday gatherings, effectively creating a new tribe for those who have been cast out of the old one. A major point of contention in 2026 is the cultural clash between the traditional iddah and the modern American work-life balance. According to religious tradition, a woman should observe a waiting period, or iddah, of approximately 4 months after a divorce, during which she is encouraged to stay home and not seek new marriage proposals. In a 1980s immigrant context, this was a period of communal support. In the hyper-competitive U.S. economy of 2026, this tradition faces massive logistical hurdles. A woman like Fatima cannot simply stop practicing medicine for 4 months without losing her hospital privileges or endangering her financial independence. Case studies from late 2025 show a growing trend of the flexible iddah. Modern scholars in the U.S. are increasingly issuing rulings that allow for a functional iddah, where the spiritual essence of the period is maintained through reflection and prayer, but the practical requirements of professional life and child-rearing are prioritized. This evolution is not accepted by everyone. Traditionalists in the community often use a woman's decision to continue working or socializing during her iddah as a justification for further shunning. This creates a psychological double bind. The woman must choose between financial survival and community approval. Furthermore, we must analyze the phenomenon of the divorce party versus the period of mourning. In 2026, a growing segment of the younger generation is adopting the Western trend of celebrating the end of a toxic marriage. These events, often shared on video platforms, feature themes of liberation and renewal. To the older generation, these parties are seen as a direct affront to the sanctity of the marital bond and a sign of cultural decay. To the participants, They are a necessary psychological tool to reclaim their identity and signal to their social circle that they are no longer in a state of victimhood. This creates a stark generational divide within mosques. We have seen instances where mosque boards have debated whether individuals who have hosted such parties should be allowed to hold leadership positions within the community. The potential outcomes of this social fragmentation are twofold. On one hand, it is leading to a more specialized and supportive subculture for divorced individuals, reducing the long-term psychological impact of isolation. On the other hand, it is creating a polarized community where the married and the divorced live in parallel worlds with very little overlap. This loss of intergenerational and interstatus connection is weakening the overall social cohesion of the American Muslim minority. We see this reflected in the data regarding masjid attendance, which shows a significant drop among divorced individuals who feel they no longer have a place in the pews. As the social war settles into a stalemate, a new and even more high-stakes battleground is emerging. It is the battle over the hearts, minds, and legal status of the children. In the year 2026, the intersection of U.S. custody law and Islamic principles of child-rearing has become a legal minefield. When the civil court grants joint legal custody, but the religious tradition suggests a different path based on the age and gender of the child, the conflict moves from the social circle into the intimate reality of the nursery and the schoolyard. What happens when the law of the land says the children stay in the U.S., but the religious interpretation suggests they should be raised in the father's ancestral home? How do modern parents navigate the complexities of Sharia-compliant upbringing in a dual household, secular environment? In the next part, we will dive into the heart-wrenching world of custody battles in 2026. We will look at the specific step-by-step challenges of the relocation clause, the rise of the religious upbringing agreement in U.S. courts, and the devastating impact of parental alienation when faith is used as a weapon. The fight for the assets was just the beginning. The fight for the next generation is where the real scars are formed. The collision between centuries-old Islamic principles of child custody and the modern U.S. legal standard, known as the best interests of the child, has reached a fever pitch in the year 2026. To understand the depth of this conflict, we must first look at the concept of had hana. Traditionally, in many schools of Islamic jurisprudence, had hana, or the right of physical custody, is often prioritized for the mother during the child's early years, frequently until age 7 for boys and puberty for girls, provided certain conditions are met. However, the American legal system in 2026 operates on a strictly gender-neutral basis. U.S. family courts do not start with the presumption that a mother or father is inherently better suited for custody based on religious doctrine. This creates a massive structural gap that parents must navigate through a series of high-stakes legal maneuvers. Imagine the case study of Miriam and David in a 2026 courtroom in Northern Virginia. David is a tech consultant and a convert to Islam. Miriam is a second-generation American of Egyptian descent. They have 2 children, ages 4 and 8. In a traditional religious setting, Miriam might expect to have primary physical custody because of the children's ages. But David, utilizing the historical trends of U.S. family law, is pushing for a true 50-50 shared parenting arrangement. He argues that his flexible remote work schedule in 2026 allows him to be just as present as Miriam. For Miriam, this feels like a violation of her religious rights. For David, it is a claim to his civil rights as an American father. The potential outcomes of this case depend heavily on how their legal teams translate these cultural expectations into the secular language of the court. One of the most significant step-by-step evolutions we see in 2026 is the rise of the Religious Upbringing Agreement, or RUA. These are specialized addendums to a standard parenting plan that go into excruciating detail. In 2026, a vague clause stating the children will be raised Muslim is no longer sufficient and is often found unenforceable by U.S. judges for being too ambiguous. Instead, modern RUAs specify everything from dietary restrictions, ensuring both households maintain a strictly halal kitchen, to the specific mosque the children will attend for Sunday school. They even include clauses for the observation of Ramadan, detailing which parent has the children for the Eid prayers on a rotating basis. Case studies from 2025 show that when these RUAs are drafted with the help of both a secular attorney and a culturally competent mediator, they serve as a vital peace treaty. However, when they are ignored, the fallout is devastating. Imagine a scenario where David, during his weekend custody, takes the children to a mainstream American fast food chain that does not serve halal meat. In Miriam's eyes, this is not just a dietary slip-up. It is a fundamental breach of their religious agreement and a threat to the children's spiritual identity. In a 2026 court, Miriam's attorney would have to argue that this consistency is vital for the children's psychological stability, rather than just a religious preference. This brings us to a darker historical trend: the weaponization of faith through religious alienation. In the high-conflict divorces of 2026, we are seeing an increase in cases where one parent attempts to excommunicate the other in the eyes of the children. If Miriam tells the children that David is not a true Muslim because he no longer attends Friday prayers, or if David tells the children that their mother's traditionalism is a form of backwardness, they are engaging in a form of parental alienation that is increasingly being recognized by U.S. courts as emotional abuse. In 2026, family court judges are more likely to appoint a guardian ad litem, who is specifically trained in religious literacy to determine if a parent is using faith to destroy the child's relationship with the other parent. Step by step, the legal process in 2026 has become a battle of experts. We see the emergence of cultural psychologists who testify on the importance of community belonging for minority children. They argue that for a child in a divorce, the mosque is not just a place of worship, but a primary social safety net. If a custody arrangement moves a child too far from their religious community, it could be argued that it is a detriment to their best interests. This has led to the inclusion of geographic radius clauses in 2026 divorce decrees, where neither parent can move more than 15 miles away from the community center or Islamic school without the other's consent. Furthermore, we must look at the 2026 reality of international travel. For many Muslim American families, spending summers with extended family in the Middle East, South Asia, or Southeast Asia is a core tradition. In a divorce context, this becomes a terrifying prospect. The potential outcome of a child being taken to a country that is not a signatory to the Hague Convention on the Civil Aspects of International Child Abduction is a permanent loss of custody for the left-behind parent. In 2026, U.S. courts are increasingly requiring travel bonds, large sums of money held in escrow that are forfeited if the parent does not return with the child. Some judges are even ordering the mirror order process, where the parent must obtain a custody decree in the destination country that recognizes and matches the U.S. court's order before the child is allowed to board the plane. In the year 2026, when a Muslim couple in the United States decides to separate, they are rarely the only people in the courtroom, even if they are the only ones physically present. They are shadowed by the heavy, often invisible presence of two entire extended families, a phenomenon we now call the in-law shadow. This is not just about meddling parents. It is about a complex, multi-generational web of expectations, financial interdependencies, and social standing that can turn a relatively straightforward civil divorce into a decade-long clan war. To understand the cultural evolution of 2026, we have to look at the case of Layla, a 32-year-old user experience designer in Dearborn, Michigan. Layla's divorce from her husband, Bilal, was triggered by a series of private disagreements, but it was set on fire by a WhatsApp group. Historical trends in the mid-2020s show that the traditional village has been digitized. Layla found herself not just divorcing Bilal, but fighting a war of attrition against his mother, his three sisters, and an assortment of aunts spread across 3 continents. To counter this, 2026 has seen the professionalization of inter-clan mediation. This is a highly structured process that differs significantly from standard civil mediation. It involves a 3-stage intake process. Step 1 is the individual assessment, where a mediator, often a team consisting of a licensed therapist and a culturally literate scholar, meets with the couple and the primary influencers from both families separately. This is crucial because in many cases, the husband or wife may actually want a peaceful resolution, but is being pressured by their parents to take a hardline stance. Step 2 is the caucus of the elders, where the parents from both sides are brought together to discuss the impact of the divorce on the family's long-term legacy, focusing on the preservation of the relationship with the grandchildren. Step 3 is the joint session where a family peace treaty is drafted. This family peace treaty is a fascinating cultural artifact of 2026. It is a non-legal but socially binding document that outlines how the 2 clans will interact post-divorce. It includes specific protocols for family weddings, funerals, and religious holidays. It stipulates that neither family will speak ill of the other in front of the children, and crucially, it sets limits on the use of social media to discuss the divorce. While U.S. civil courts cannot enforce the spiritual components of such a treaty, they are increasingly incorporating the behavioral stipulations into the final parenting plan. The data suggests that families who go through this clan-level mediation see a 60% reduction in post-divorce litigation compared to those who only focus on the individuals. However, when this mediation fails, we see the emergence of the Great Rift. In 2026, where many American Muslim families are still interconnected through cousin marriages or long-standing business partnerships, a divorce can lead to a total collapse of the social fabric. We have documented case studies where entire local businesses were dissolved because the owner's children were divorcing, and the resulting animosity made professional cooperation impossible. This is the real cost of the village's failure to adapt to modern realities. The collective mindset, which is supposed to provide a safety net, instead creates a trap that ensures the trauma of the divorce is felt by dozens of people, not just two. Consider the role of the mother-in-law in this 2026 evolution. The archetype is shifting. While the meddling mother-in-law remains a trope, a new historical trend is emerging: the supportive, bridge-building matriarch. We are seeing a rise in mothers-in-law who, having witnessed the pain of their own generation's silenced divorces, are stepping in to protect their daughters-in-law. In some cases, these women are testifying against their own sons in civil court when they witness financial abuse or neglect. This represents a seismic shift in the cultural definition of loyalty. It suggests that for some, the ethical principles of justice in Islam are beginning to outweigh the tribal instincts of blood. This leads us to a deeper question about the future of the American Muslim family. If the village is broken, and the in-law shadow is too dark to navigate, where does the individual go? In 2026, the answer is often found in the creation of an intentional village, a hand-picked group of friends, mentors, and professionals who provide the support that the biological family cannot. Layla eventually found her peace not by reconciling with her in-laws, but by building a new social ecosystem that respected her autonomy. This is the bittersweet reality of the cultural evolution. To save the self and the next generation, one must sometimes walk away from the very structures that were designed to protect them. But as these families fracture and reform, a new challenge arises on the horizon. The divorce is finalized, the assets are divided, and the in-laws have retreated to their respective corners. Now comes the most difficult phase of all: the hunt for a second chance. In a community that still places a massive premium on the first marriage, how does a divorced man or woman navigate the brutal, high-tech, and often unforgiving world of the 2026 remarriage market? In the next part, we will peel back the curtain on the hidden world of the halal dating apps for the second-timers. We will explore the data on the divorce discount, the harsh reality of how much a person's marriageability drops after a first marriage, and the controversial rise of the second wife industry as a desperate solution for divorced women. We will also look at the rise of the blended baraka, the specific step-by-step challenges of integrating two sets of children from previous marriages into a new 2026 household. The search for love after a deep-dive divorce is the ultimate test of faith and resilience. Are you ready to see how the rules of the game have changed? The search for a second chance at companionship in the year 2026 has become a high-stakes digital operation for the American Muslim community. The transition from a first marriage to a potential second marriage is no longer a quiet matter of family referrals. It is an industry. To understand the mechanics of this, we must look at the experience of Ahmed, a 40-year-old financial analyst in Jersey City. Following his divorce in 2024, Ahmed found himself entering a marriage market that had fundamentally changed since he was first a suitor in his 20s. In 2026, the primary gateway for remarriage is a suite of sophisticated, algorithm-driven halal dating platforms that have developed specific, robust features for the divorced population. In our current year, these apps have moved beyond simple swiping. Historical trends show that for individuals over the age of 35, the most popular platforms now include a verified divorce status badge. This is not just a label. It often involves a step-by-step verification process where users can voluntarily upload a redacted copy of their civil divorce decree or a letter from a recognized Islamic council. This level of transparency is a response to years of case studies involving individuals who misrepresented their marital status or their parental obligations. For Ahmed, the app experience is a lesson in the data of desirability. He quickly realizes that the filters used by the younger, never-married demographic frequently exclude him entirely. This is the reality of the 2026 marriage market. It is a segmented ecosystem where the divorced are often siloed into their own search category. This brings us to a controversial sociological phenomenon known as the divorce discount. This term, coined by community researchers, describes the perceived decline in an individual's social capital or marriageability after a first marriage ends. Data from 2025 and 2026 indicates a significant gender disparity in how this discount is applied. For men like Ahmed, the discount is often smaller and temporary. If he is financially stable and has a good relationship with his children, he is frequently seen as an experienced candidate who has learned from his past mistakes. However, for women in the same age bracket, the historical trends suggest a much steeper uphill climb. A divorced woman with children often faces a cultural barrier where potential suitors, or more accurately, the families of potential suitors, view her as having too much baggage. The potential outcomes of this disparity are driving a resurgence of a highly controversial and underground trend in the United States: the religious-only second wife arrangement. While polygyny is strictly illegal under U.S. civil law and can lead to charges of bigamy if a second civil marriage is attempted, we are documenting a rise in private religious contracts where a divorced woman agrees to become a second wife to a married man without civil filing. This is often seen as a desperate solution for women who feel they have been priced out of the monogamous marriage market. In 2026, these arrangements are fraught with legal and financial risk. Since there is no civil recognition, the second wife has zero rights to inheritance, Social Security benefits, or marital asset division in the event of a second breakup. Case studies from the last 18 months reveal a pattern of these women being left in extreme financial precarity, highlighting why professional mediators and scholars are increasingly speaking out against this practice as a form of social exploitation disguised as a religious solution. For those who do find a compatible partner for a monogamous second marriage, they face the step-by-step challenge of the blended baraka. This is the process of integrating two different family systems, often with multiple sets of children, into a single 2026 household. The logistics are staggering. Imagine Ahmed marrying Hina, who also has 2 children from a previous marriage. They now have 4 children, 3 different ex-spouses to manage through co-parenting apps, and 2 different sets of in-laws who may or may not be on speaking terms. In 2026, successful blended families are utilizing what we call the household constitution. This is a formal written agreement between the new spouses that outlines the rules for discipline, the division of labor, and the specific spiritual routines for the house. A critical component of this household constitution is the financial firewall. In a second marriage, especially when there are children from a previous union, the standard joint account model is often discarded in favor of a tiered system. Historical trends in 2026 show that successful couples maintain 3 types of accounts: his, hers, and ours. This protects the inheritance rights of the children from the first marriages. If Ahmed has a college fund for his daughter from his first marriage, the 2026 legal norm within the community is to keep that fund in a separate trust that his new wife, Hina, cannot access. This level of financial pragmatism is a sharp departure from the idealistic, all-in approach of the 1.0 marriage, but it is seen as a necessary evolution to prevent future legal battles. The psychological hurdles of the 2.0 marriage are equally intense. We are seeing a rise in what counselors call the comparison trap. Ahmed might subconsciously expect Hina to react to conflict in the same way his first wife did, leading to defensive behavior before Hina has even spoken. To combat this, 2026 has seen a boom in second-timer retreats. These are weekend-long intensives designed specifically for blended Muslim families, focusing on the unique challenges of step-parenting and the religious ethics of treating all children in the house with equity. The data suggests that couples who participate in these intensives before their nikah have a significantly higher rate of marital stability over the first 3 years. Furthermore, we must look at the role of the ex-spouse in the 2.0 marriage. In 2026, the concept of the friendly ex is beginning to take root in the American Muslim community, albeit slowly. Case studies show that when the original divorce was handled through the mediation and peace treaty processes we discussed in earlier parts, the integration of a new spouse is much smoother. If Ahmed's first wife has already moved on and finds Hina to be a positive influence on their children, the potential outcomes for the children's mental health are vastly improved. However, when the 1.0 divorce was a digital or social war, the 2.0 marriage often becomes the next front in that war, with the new spouse being treated as an interloper or a replacement. The evolution of the second marriage in 2026 is ultimately a story of resilience. It is about individuals refusing to be defined by a past failure and seeking to build a more conscious, legally protected, and spiritually grounded union. They are the pioneers of a new family model that is more American in its flexibility and more Islamic in its focus on justice and contractual clarity. They are proving that the end of one chapter is not the end of the book, but the beginning of a more complex, albeit more rewarding, narrative. But as these new families form and the community shifts its gaze toward the future, a massive and overlooked segment of the population is falling through the cracks. While many find a second chance, many others find themselves completely alienated from the faith itself. The pain of the divorce, the judgment of the mosque, and the failures of the legal system have led to a quiet but accelerating exodus. What happens when the divorced person decides that the mosque is no longer a safe place for them? What is the impact of the great demosking of the divorced? In the next part, we will explore the silent epidemic of spiritual detachment. We will look at the rise of the unmosqued population, individuals who still identify as Muslim, but have stopped attending community events and Friday prayers due to the trauma of their marital breakdown. We will dive into the data on how divorce is a primary driver of secularization within the second and third generations, specific step-by-step failures of religious institutions that are driving people away. The final cost of a messy divorce isn't just measured in dollars or social circles. It is often measured in the loss of a soul to the community. Are you prepared to look at the side of the story that the leaders are too afraid to discuss? The quiet exit from religious life following a divorce in the American Muslim community is a phenomenon that sociologists in 2026 are calling spiritual displacement. This is not a sudden rejection of faith, but a slow, agonizing drift away from the institutions that once provided a sense of belonging. To understand how this happens, we must look at the experience of Michael, a 45-year-old healthcare administrator in Philadelphia. Michael is a devout man who served on his mosque's fundraising committee for a decade. When his marriage ended in 2024, he didn't expect the mosque to provide a legal solution, but he did expect it to provide a sanctuary. Instead, he found that every Friday sermon on the sanctity of the family unit felt like a direct indictment of his personal failure. In the year 2026, the historical trends regarding mosque attendance show a startling data point. Nearly 35% of divorced individuals stop attending congregational prayers within the first 2 years of their separation. This is the unmosqued population. For Michael, the process of detachment followed a specific step-by-step breakdown of trust. It began with the social cold shoulder. When he walked into the prayer hall, the men who used to greet him with warmth now looked away or offered a stiff, formal nod. The second step was the pulpit pressure. In 2026, many American imams, struggling to stem the tide of rising divorce rates, have doubled down on sermons that emphasize marriage as the only path to a stable community. While intended to strengthen families, these messages often alienate those whose families have already fractured, making them feel like second-class citizens in the house of God. This institutional failure is rooted in a theological misapplication of the concept of sabr, or patience. In many case studies from 2025 and 2026, we see a recurring pattern where individuals seeking help for marital distress are told to have more sabr, regardless of the severity of the situation. For a woman in an emotionally abusive relationship or a man facing extreme financial exploitation, being told to simply be patient is experienced as spiritual gaslighting. It reframes their legitimate suffering as a lack of faith. When the marriage inevitably ends, the individual associates the trauma of the breakup with the religious language used to keep them in it. This leads to a profound sense of betrayal. They don't just leave their spouse, they leave the structure that they feel prioritized an institution over their human dignity. The gendered nature of this spiritual toll is even more pronounced in 2026. Consider Sophia, a 30-year-old graphic designer in Seattle and a second-generation American. For Sophia, the mosque was her primary social network. After her divorce, she found that the community's support was conditional on her remaining silent about the reasons for the split. When she began to speak openly about her need for mental health support, she was met with whispers that she had become too westernized. In the year 2026, many religious spaces still lack a clear professional protocol for post-divorce reintegration. There are no welcome committees for the newly single, no specialized support groups that bridge the gap between religious guidance and modern therapy. As a result, Sophia found herself gravitating toward secular spaces where her identity was not tied to her marital status. She didn't stop believing in the core tenets of her faith, but she stopped identifying with the community that practices it. By 2026, this has led to the rise of the third space, community centers and nonprofit organizations that are culturally Muslim but operationally secular. These spaces have seen a surge in membership from the divorced population. They offer the cultural familiarity of the mosque without the perceived judgment of the religious hierarchy. However, the potential outcome of this shift is a hollowing out of the traditional mosque. If the most resilient and experienced members of the community, those who have navigated real-life crises, are pushed out, the mosque becomes an echo chamber of the idealized, never married, or the comfortably settled. This loss of diversity in life experience weakens the community's ability to mentor the next generation. Furthermore, we must analyze the devastating impact on the third and fourth generations. The children of these 2026 divorces are watching how their parents are treated. When a child sees their mother or father being ostracized by the community leaders they were taught to respect, it creates a crisis of authority. We are seeing a historical trend where the children of messy, community-shamed divorces are the most likely to identify as religiously unaffiliated or knowns by the time they reach college. For them, the mosque is not a place of peace, but the place where their parents' pain was made public and their family's dignity was stripped away. This is the generational cost of spiritual displacement. The step-by-step failure of religious institutions in 2026 often begins at the intake level. Most mosques do not have a private, confidential way for individuals to report a divorce. It is often handled by a volunteer board or a single imam who may not have any training in psychological trauma or U.S. family law. This lack of professionalization leads to leaks of private information, biased mediation, and a total lack of follow-up care. As we reach the conclusion of this deep dive into the spiritual toll of divorce, we have to look forward. We have seen the legal battles, the financial wreckage, the social shunning, and the spiritual displacement. But what does the ultimate evolution of this community look like? Are we witnessing the slow dissolution of the American Muslim family, or are we seeing the birth of something entirely new? In the final part of our masterclass, we will pull all these threads together to reveal the blueprint for the 2026 and beyond American Muslim identity. We will explore the rise of the equitable household, the end of the immigrant marriage model, and the emergence of a new social contract that could change everything. The final piece of the puzzle is about more than just surviving a divorce. It is about thriving in a world that has been completely redefined. Are you ready for the final revelation of where we are all heading? The evolution we are witnessing in 2026 is not the destruction of the American Muslim family, but its radical reconstruction. To understand the blueprint of this new era, we must look at the life of Maya, a 29-year-old law student in Atlanta. Maya represents the third generation of Muslims in the United States, and her approach to marriage and its potential end is fundamentally different from anything the community saw in the 1980s or 90s. For Maya, the immigrant model of marital endurance, characterized by silent suffering, total financial dependence, and a fear of community gossip, is not just outdated. It is seen as a theological and psychological failure. In 2026, the potential outcomes for families like Maya's are being shaped by a new social contract that prioritizes equitable partnership over patriarchal stability. Step by step, we are seeing the emergence of the equitable household. This is a model where the marriage contract, or nikah, is treated with the same legal rigor as a high-stakes business merger. Historical trends in 2026 show that 80% of young Muslim American couples now insist on a comprehensive civil prenuptial agreement before the religious ceremony even takes place. This is not seen as a lack of trust, but as an act of mercy and clarity. In Maya's case, her contract includes a sunset clause for her deferred mahr, a specific mediation mandate that bypasses traditional family elders in favor of professional arbitrators, and a transparent disclosure of all premarital debts and assets. This level of preparation is a direct response to the forensic nightmares and social wars we explored in earlier parts of this masterclass. The first pillar of this 2026 evolution is the death of the tribal village and the rise of the intentional community. Maya and her peers are no longer looking for validation from a mosque board or a distant aunt in Karachi. Instead, they are building social networks based on shared values and professional ethics. When a conflict arises in 2026, the first step is no longer a call to the parents, but a session with a specialized marital coach who is trained in both Gottman method therapy and Islamic ethics. Data from 2025 indicates that couples who utilize these hybrid professional services see a 50% higher rate of successful reconciliation or, failing that, a 70% higher rate of amicable separation. This is a massive shift from the high-conflict, community-wide explosions of the past. The second pillar is the total economic mobilization of Muslim women. In 2026, the financial independence of women is no longer a point of contention. It is the baseline. This has fundamentally altered the power dynamics of the household. Imagine if Maya faces a situation where the marriage is no longer healthy. Because she has her own career, her own credit score, and her own legal representation, the potential outcome of a divorce is no longer a descent into poverty or a loss of social standing. This economic parity forces a higher level of accountability from both partners. In the 2026 model, the marriage must be maintained through mutual respect and emotional intelligence because the traditional levers of control, money, and social isolation have been neutralized. We must also look at the theological shift occurring in American Islamic schools and seminaries. In 2026, there is a historical trend toward a more compassionate interpretation of divorce as a tool of mercy. Scholars are increasingly highlighting the prophetic tradition where divorce was a recognized and normalized part of life, rather than a catastrophic failure of faith. Case studies of new mosque curricula in cities like Chicago and Los Angeles show a heavy emphasis on emotional health and the rights of the individual within the family. They are teaching a generation of young men that being a qawwam, or a protector and maintainer, is not about exerting authority, but about providing a safe and equitable environment for their wives and children to thrive. The third pillar is the integration of the civil and the spiritual. In 2026, the American Muslim community has largely moved past the duality of being civilly divorced but religiously married. Through the widespread adoption of the standardized divorce addendums we discussed earlier, the community has effectively solved the problem of the religious lockout. If a man in 2026 refuses to grant a religious divorce after a civil decree, he finds himself not just socially shunned, but legally liable in some jurisdictions for breach of contract. This harmonization of the two legal systems is the crowning achievement of the last decade of legal activism within the community. But what about the children of 2026? Their reality is the most profound evolution of all. They are growing up in what we call the blended Baraka households, where co-parenting is handled through high-tech apps, and where the respect between former spouses is seen as a religious duty. The historical trends suggest that children from these reformed divorced families show higher levels of resilience and cultural literacy than those from high-conflict traditional households that stayed together purely for appearances. They are learning that a family is defined by the quality of its relationships, not just the presence of two parents under one roof. As we look toward the end of this decade, the American Muslim experience is becoming a global benchmark. The potential outcomes we have explored, from the professionalization of the MAR to the rise of digital honor protection, are now being studied by communities in Europe, Canada, and even in the traditional centers of the Muslim world. The U.S. has become a laboratory for how a minority faith can adapt its ancient principles to a modern, secular, and democratic landscape without losing its soul. Maya and her generation are not just surviving. They are leading a cultural renaissance that is making the community more robust, more honest, and more just. The final revelation of this masterclass is that the evolution of divorce has actually strengthened the institution of marriage. By making the exit process clear, fair, and transparent, the community has raised the bar for what it means to enter into a union. Marriage in 2026 is no longer an automatic rite of passage. It is a high-level commitment made by individuals who are fully aware of their rights and responsibilities. The fear of divorce has been replaced by a respect for the contract. This is the ultimate victory of the American Muslim experiment, the creation of a family model that is both deeply rooted in faith and fully adapted to the complexities of the 21st century. This journey through the landscape of cultural evolution, legal complexity, and spiritual resilience has revealed a community in the midst of a profound transformation. We have seen the scars, the battles, and the hard-won victories. But as we close this deep dive, we must realize that the evolution of the family is only one part of a much larger story. The shifts we are seeing in the home are a reflection of a massive tectonic move in how authority itself is being redefined in the digital age. The mosque, the home, and the school are all being disrupted by a new force that is changing how we perceive truth and leadership. What happens when the traditional structures of authority completely collapse and are replaced by an algorithm? How will the next generation of leaders be chosen? And what does it mean for the future of faith in an AI-driven world? The family was the first battlefield, but the next one is the very definition of identity itself. In our next deep dive series, we will explore the rise of the digital caliphate and the invisible war for the hearts and minds of the global youth. You thought you understood the evolution of the culture, but the most radical changes are yet to come. Are you ready to see how the code is being rewritten for the next 1,000 years?